All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Phil, when I start Lawyer on the Clock today, I've got a question for you first. Did you happen to visit?
You're always trying to trick me up.
Did you happen to visit Starbucks today?
I got my star. It's empty as well. Now, I'm trying to support the cause. I hear they have some activity going on.
They did. Today's Red Cup Day. Were you aware of that?
I only because I heard about it on the radio, but I'm not sure what Red Cup means. I mean, I'm familiar with the Red Nose Day. Now we have Red Cup Day. Tell me about
You're wearing red in honor of Red.
I'm wearing red. Well, I'm getting ready to go to Indiana. As soon as I leave here at noon, I have to speak to a SHRM audience there. So I'm wearing the AIM colors. Consider this uniform, Burt. It's like a tie for a lawyer.
Caffeinate up on the way. Get some more Starbucks. Today's Red Cup Day, and if anyone orders a any size handcrafted holiday or fall beverage, either hot, iced, or blended, they will receive a free grande. That's a 16-ounce Starbucks. So this is Red Cup Day. This is their biggest day of the year. And, of course, you may ask yourself, Phil, you might ask me, why in the world are you talking for Starbucks and giving them an advertisement on our program?
Burt, why in the world are you talking for Starbucks and giving them an advertisement?
You're brilliant. You're brilliant. Well, today there's a big issue going on because there are Starbucks baristas at more than 200 locations nationwide who are intending to strike during the company's busy Red Cup Day promotion today. So there's significant activity going on. We all know that that many Starbucks locations around the country have unionized over the past few years. And those workers at the unionized locations, and frankly, some of the non-unionized locations, are contemplating striking. In fact, nearly 2 years after the union first won an election at a Starbucks store, 360 of Starbucks' roughly 9,000 company-owned locations have voted to unionize. No location has come close to a collective bargaining agreement with Starbucks yet. Keep that in mind.
Oh, really? That's very interesting. 360, none of them are even close to a collective bargaining unit agreement.
Correct.
I wonder how many of the employees that voted are still working at those Starbucks today. That'd be an interesting fact, wouldn't it?
That would be, yeah. And again, I think the significant fact there, Phil, is, excuse me, not just the 360 stores of the 9,000, which by my math is roughly what, 0.3%? Is that right? If I'm doing my math correctly, it's 9,000. Well, 3%, I guess. So you could do the math for me, but I think the significant number there is that this is more than 2 years after the first union won an election at a Starbucks.
Your math is pretty close, Burt. Well done.
3%. All right.
It's
so 3%,
about 4% almost. Yeah.
All right. 4% of the Starbucks stores are unionized. And the first one unionized 2 years ago, and none of them have contracts yet. And I think that's what a big reason of the strike is to put some pressure on the company on their biggest day of the year, on Red Cup Day, to tell Starbucks, sit down, bargain contracts with the employees, and get moving here. So Starbucks in the news for you today. Let's shift gears, Phil, if you don't mind. I want to chat about the Supreme Court real quickly. And
I hear now, before you do that, I hear there was a big Supreme Court victory here in this great state of Missouri, Burt.
There was. I appreciate you.
Congratulations. Yeah.
Thank you, Phil. I appreciate that. Yes, as our listeners from last week know, I talked about it on the program that I had the opportunity, a great opportunity, to argue my first case during my career in front of the Missouri Supreme Court. About 2 months ago, actually, in late September. And the issue had to deal with arbitration agreements. And the court considered two specific issues. They ruled on one of them in my favor, which meant they didn't need to rule on the second one. And the specific issue in that case was whether there was a valid arbitration agreement in the particular case. And the court analyzed and determined, yes, there was a valid arbitration agreement. And then because that valid arbitration agreement contained what's called a delegation clause, which delegates to the arbitrator to determine whether there is an enforceable arbitration agreement. So again, two different concepts, validity and enforceability. The court determined it was valid, which means there is a contract. And then the arbitrator will get to decide whether the contract is enforceable or not. Kind of a fine legal distinction. I feel like I'm on really solid footing because the court specifically left intact the only two cases on the point on enforceability that go in my favor. So they did not overrule those two cases that go in my favor. And so I feel very comfortable that that Supreme Court victory is going to be a huge victory for my clients. So I appreciate you bringing that up, Phil.
Absolutely. There you go. The great Burt Garland. If you have an employment law issue, look him up today at Ogletree Deacons. He's one of the great shareholders here in the St. Louis office. Great job, Burt. Really proud of you there.
Appreciate it, Phil. I thank you. So yeah, let's chat real quickly about what the Supreme Court did with respect to a New Jersey COVID vaccine mandate. Remember COVID vaccine mandates, Phil? I think it's how we got started.
Is that still a topic? Is that still a topic?
So in this case, 4 New Jersey nurses failed to convince the U.S. Supreme Court to hear their case challenging a now rescinded state mandate requiring healthcare workers to get a COVID-19 vaccine booster shot. This just happened this past Monday. The nurses in that case had received their initial vaccine, but they declined additional booster shots for various reasons, including, and I'm going to quote this, their quote, fundamental rights of privacy, bodily integrity, and the liberty to refuse unwanted medical treatments, end quote. Now, the Third Circuit Court of Appeals agreed with the state that the appeal was moot because the governor in that state, Governor Murphy, had since revoked the executive order, but the appeals court then remanded the case to the district court to determine whether the entire lawsuit was moot. The state's motion to throw out the entire case remains pending. So the case is not fully concluded yet. It is possible it could work its way back up through the Court of Appeals into the Supreme Court. The Supreme Court's 2000 decision in a case called Friends of the Earth versus Laidlaw Environmental requires that it must be absolutely clear for the allegedly wrongful behavior could not reasonably be expected to recur for a matter to be moot. And so here, because the governor had rescinded the vaccine booster mandate, the Supreme Court declined to take the case. So I think, again, whether the entire lawsuit is moot or not might make its way back up. Of course, people who are in favor of the vaccine mandates are heralding this case as a massive win, but I don't think it's quite as massive of a win for those folks as they think. It's really just the Supreme Court decided not to hear the case at this time. I don't think we've heard the last of it.
All right. Well, we'll keep our ears open for future decisions and noise in that area as well.
Phil, I know when you head over to Indianapolis today, you won't be making your way all the way up north to Chicago, but you will be traversing the state of Illinois, correct?
I will be, yes. And maybe I'm going to have to accrue some hours for my paid time off, yeah?
Well, yeah, that would be under the Illinois Paid Leave for All Workers Act.
But not until next year.
Yep, not until next year, which by the way, Phil, pales in comparison to what Chicago has just done to employers in their fine city. So on November 9th, the Chicago City Council adopted the Chicago Paid Leave and Paid Sick and Safe Leave Ordinance, which expands the current Chicago Paid Leave Ordinance to provide eligible employees, get this one, the ability to earn 40 hours of paid leave and I stress and 40 hours of paid sick leave every 12 months. That's 80 hours. That's 2 weeks that employers will be forced to provide employees paid time off in a separate bank of paid sick leave every 12 months.
Yeah. And, it's when you think about that, my theory is they're doing what they can to attract people to the city of Chicago, right?
Well-
I mean, they're doing all they can to try and get people to come into the city or to stay in the city and to appeal to those voting population of the city, obviously, is part of their duty, I think, as a public servant. But that type of thing on top of the minimum wage that they've implemented for restaurant, for, those servers and different things, I think it's going up to $15 or $16 an hour. I just don't know who's going to afford the vacation there, eat there, stay there, and deal with the outcome of that additional expense.
Well, obviously, they're trying to appeal to voters and trying to get voters a material benefit, which would be great. But as we all know, that for every action, there's an equal and opposite reaction. And the question will be whether businesses end up leaving the city and therefore they don't employ people in the city of Chicago. So that'll remain to be seen how that pans out. I do think what's really interesting about this law in particular is, just like the Illinois Paid Leave for All Workers Act, this law is clearly targeted at employers in the restaurant and retail industry.
Yeah.
The fact of the matter is that most employers that aren't in the restaurant and retail industry do provide a form of paid leave, paid time off, paid vacation. Usually it's at least a week, maybe it's a couple of weeks. And so they may already be in compliance with this law. But traditionally, restaurant and retail sectors do not provide these types of benefits. And so that's the industry. Those are the two industries where this is really going to hit hard.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.